Hey folks, I need to enlist your help on an issue that's really important, your employment rights. You probably don't know this, but working for FUSD, and this is true of basically all other districts in the state too, you actually don't have the same civil liberties and protections that a civilian has, but specifically with discipline, or if you were to get in trouble or something like that, or just be accused of something that wasn't even true. So let me just give you two quick examples. The Sixth Amendment of the Constitution gives citizens the right to confront the witnesses against them, and be able to cross-examine those witnesses if in a trial, right? But the way our policy works, as well as other districts across the state, is that if there's an allegation that comes against you, even sometimes a minor thing that you might have said, made some very mildly inappropriate or borderline comment or something, which could have been interpreted wrong as well. But anyway, you can basically not really have the opportunity to clearly know who's accusing you in some cases. Oftentimes you'll sit there at home for days after you're sent home on paid admin leave, and you don't even know what the charge is against you. I'm sure we've all heard of the concept that the police can only hold you for 24 hours before charging you with a crime. I think the idea being that, if they're going to take away your liberty or encroach on your liberty, you deserve to know exactly in a transparent way what is going on. For us in the district, there's really no strict rules about it at all. So there have been cases where someone was sent home to be investigated on some charge. Again, sometimes a very minor thing. We're not talking about, horrible things like hitting a child or something, which you can understand if that takes as long as it needs to investigate very thoroughly. But if you're just saying something minor, or having been alleged to do something minor, you can be sitting at home for days before you even talk to the investigator and learn what it is that you're charged with. Even when you do talk to the investigator to be interviewed, in most cases, in my experience, you're still not really told, this is basically the area we're dealing with, this is the type of allegation that we think. You're just asked these questions. And the questions, of course, they're not from nowhere. They're because usually the investigator has talked to the kid or the parent or whoever's making the complaint first. And, from that, they ask you these questions trying to ascertain the truth of the situation from your perspective. But the problem is you get the questions kind of in these little fragments, right? And so just getting asked piece by piece a tiny little piece of a quote that you're alleged to have said, sometimes weeks before or months before, as the case may be, and sometimes you can't even remember what, having said anything remotely like that, which can make you look guilty, because you're like, I honestly don't recall. That's the answer that a politician gives to escape wrongdoing, or a corporate leader, right? And so the other piece of this is that there's no limitation in our current policy for how long you can be gone. And so people have been out of the classroom. Usually it's, 2-3 weeks, even for a small thing. And meanwhile, your students are wondering, your colleagues are wondering what the heck happened. You don't know how to talk about it when you come back, even if you're exonerated. But I've seen it go up to 6 to 8 weeks that a person is out only to then be exonerated. Okay, apparently there was nothing there. So these to me are real problems, just for fairness, for a sense of civil liberties, and a feeling of general safety and protection at work, that you will have some rights and clear guidelines about how you can be treated. So the good news is, two pieces of good news. One is that the superintendent is already aware of some of these issues from my perspective, and or from FEA's perspective as a policy watchdog, and has already indicated a willingness to take a look at these policies and work on them. But I don't want to do that in isolation. I want your input and help to really look at this with me and think through how we could do this better. Because the other piece of good news is that state law doesn't mandate that our system be, somewhat non-transparent or, kind of make you feel like a criminal for sometimes a long period of time before you even know what's happening to you. It's just district policy, and most districts across the state have the same policy for these things. But we have policies that in some cases conflict. So one set of policies appears to give you rights to kind of confront your accuser or learn what's going on, and then another set of related policies don't give you any rights at all. And it's hard for the employee or their advocate, who's often me, to know how to even ensure their rights are protected because we don't know which policy is being invoked. So anyway, it's kind of a mess the way it is right now, but it's totally fixable. And I want, if you're interested, if this is something that inspires you to make a positive change, please just reply to the email that contains this link and let me know that you're interested. We'll form a little committee. It'll probably only have to meet a couple times, and we can just kind of go through the several different policies, how they sort of conflict, and what we think the best way to solve them is, and ultimately just make this safer, happier place to work and for our kids to learn without sometimes feeling like it's a bit of a witch hunt, or that you've been turned into public enemy number one for one very minor allegation. All right, let me know. Thank you.